Judge, I'd like to show my client's medical records to the jury. May I have permission to do that? The defense attorney jumps up, yells, "Objection, Judge! He's got to redact that medical record before showing it to the jury." What does it mean that I have to redact portions of the medical record? Come join me as I share with you some great information and I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. What the defense attorney is saying is that there's certain information contained in the medical record that the jury does not need to see. Now, he's not saying that there's harmful information in there. He's saying that there's stuff in there that is not relevant to what the jury's purpose and function is. You see, in any civil case here in New York involving an accident matter or medical malpractice or wrongful death, the jury's function is to be the trier of fact, to determine whether we are more likely right than wrong that what we are claiming is true. The jury has to decide which set of facts they believe. So now when the judge says, "Mr. Oginski, you have to redact part of that record," what that means is I now have to physically remove certain portions of that hospital chart so that now when the jury actually sees the record or takes it in with them to the jury room to deliberate at the end of the case, now they're not going to be exposed to that information that the judge has decided that is improper for them to see. Now let me give you a great example. So let's say this is a car accident case and the injured victim had some alcohol earlier in the evening. Let's say he was a passenger, right? So the passenger gets T-boned at an intersection. And now in the emergency room, the nurse learns that this passenger who was now hit and is significantly injured was at a party or he was out with some friends and he had a couple of drinks. Does the fact that he had a couple of drinks have any effect whatsoever, being a passenger, on how this accident occurred and whether the other driver was careless? The answer is no, it doesn't. Now, if the jury were to see that and not understand whether or not it's related, they may think, hey, this guy was drinking. Maybe he was drunk. So now where the judge has decided that that information is not relevant for the jury's consideration, now either I or the defense attorney will then have to physically remove that from the entire medical chart. And by the way, I have to tell you, if we remove something, I have to show my adversary exactly what I'm removing. I have to show him the exact page, I have to show him the section, because he might object to certain things that I am removing that he thinks shouldn't be removed, even after the judge says I have to remove certain things. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these civil cases here in the state of New York. You know, I recognize and acknowledge that you're watching this video because chances are you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions just like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.